All right, all right. Apologies, everyone. Sorry, we had some technical difficulties at the beginning. Um, I hope it didn't inconvenience anyone too much. So we will just get started here. Thank you so much for joining us. Thank you for waiting. Um, my name is Tammy Glover Fowler. I am the Legal and Compliance Director for Contact Center Compliance. And we offer a cloud-based software so that you could comply with TCPA. For example, we have Do Not Call Scrub, Reassign Numbers Database Scrub, a Litigator Scrub. We also help with caller ID remediation, and we have a compliance guide, which is a tool that houses all of the the federal and state telemarketing regulations, so you can query that to get information that you need. So that is enough about me. Let me introduce our guest. Bill, you are on mute. This is Bill Rainey. He is an attorney with Koplovitz, Lamb, and Rainey. His area of practice is also telemarketing, First Amendment, privacy. He has a wide range of clients from international to small independent companies, and he also advises on data breaches and privacy and things like that. Bill, would you like to say a few words?
Yeah, thank you very much, Tammy. It's a pleasure being here today. Tammy and I have worked together for 20 years. It's not that long, it's been very close to that. And she has been an absolute joy to work with, both with her current company and previous employers. She is exactly the type of compliance employee I would want on a file or a matter if it was my company. And I really can't say higher praise for her. She's conscientious, she's detail oriented, and she's thorough. And that's what any business wants in a compliance team, let alone a team leader like Tammy. So thank you for inviting me to be here, and it's been a real pleasure working with you through the years.
Yes.
My firm, Koplovitz, Lamb, and Rainey, is in Kansas City, Missouri. We represent entities with regard to compliance with state and federal privacy and telemarketing laws, and I've been practicing for close to 30 years, so I've been doing it for a while. And Tammy asked me to speak today about AI contacts with consumers, whether that be by telephone, text, or email, and the legal regime applicable to that sort of contact. So I will begin whenever, but that's a brief update about me and my relationship with Tammy. And Tammy, let me know what you want me to do next.
Sure, sure. Let's just go over our title here, Compliant Use of AI and Understanding First Amendment Rights as it relates to pre-recorded calls. So let's just talk about what is a pre-recorded call. We understand TCPA calls it an artificial voice pre-recorded message. TSR says it's a pre-recorded message. Can you give us an example of what a pre-recorded call is?
Sure. This is one of two areas of restrictions in the TCPA. The first is the National Do Not Call list, and the second are restrictions on the use of pre-recorded or automated calling, generally to cell phones, but to landlines as well. The statute was passed in 1992, where there weren't as many cell phones, if any, and that's totally flipped now, and there might not be any landlines left. So really, I'll focus on the restrictions to cell phones. And the Telephone Consumer Protection Act allows pre-recorded or artificial voice calls only to cell phones with prior express consent. or in the event of an emergency. So we can put emergency to the side. That means something that is necessary to the health of an individual. Power outages are emergency messages, but generally a marketing message or an account message is not going to be an emergency. So we're going to put that aside. Artificial or pre-recorded uses the language of the statute. It's the plain English. And so an artificial intelligence voiced call is an artificial call treated exactly like a pre-recorded call for the purposes of the TCPA. And this law has been around since 1992. And there are state laws dealing with pre-recorded voices from before that. And, you know, it wasn't the same technology. It was probably a cassette recorder that was manually dialing or sequentially dialing numbers. But that doesn't help the AI user now that those statutes are 30 years old or more. They still apply. So somebody using an artificial intelligence voiced call is going to have to comply with the TCPA and state law regarding pre-recorded calls, which are very restrictive.
So this regulation stands up.
Yeah, and regretfully it does. So it's not a prohibition. It's much more of a situation where you have to have your compliance team look at it. That doesn't necessarily mean a lawyer, but your compliance team needs to look at these before your business starts a campaign, no matter what pie in the sky or ROI a vendor promises you. You can be left holding the bag for a class action lawsuit with statutory damages of $500 per call. So the TCPA doesn't require any proof of harm, and $500 a call multiplied by any number of calls quickly becomes a huge amount of money. So the catastrophic downside is there, but you can do it right. And I want to give an example of how unscrupulous vendors tricked legitimate businesses in an area that was developing probably 10 years ago. It's been resolved now, but it's very similar to the AI pitches that my clients are getting now, and that's ringless voicemail. Ringless voicemail is a system where a business can leave a message on somebody's cell phone and the cell phone never even rings. And so a pre-recorded voicemail ends up in my cell phone. It might say, you know, you have an appointment at your doctor. It might also say, you know, buy this stock, it's about to go to the moon. And the vendors of ringless voicemail said, oh, it's not a call. It's not subject to the TCPA because the phone never rings. And over the course of 10 years, that claim has been uniformly rejected by court cases. The Telephone Consumer Protection Act says it shall be unlawful for any person within the United States to make any call using an artificial or pre-recorded voice to any telephone line assigned to a paging service, cellular telephone service, etc., absent prior express consent. So these ringless voicemail people were saying, oh, it's not a call. And all the judge had to do was look at the statute here that says call. And they're like, how is it not a call? And there are plaintiffs' attorneys on the other side who are really smart, and they're being motivated by vast amounts of money. And they're saying, you know, the term call is used in the statute, and it has the plain English language of a call. Anybody who says this voicemail got to my cell phone, was I called? They're going to say, of course they are. And the ringless voicemail people relied on a very convoluted argument that the FCC had classified this not as a call, but as a data service or something like that. You know, that might be the case, but when a judge looks at a statute, the judge looks at the word, and if it's unambiguous, they don't go to what the FCC said. That's called statutory construction. A call's a call. Everybody says this a call, and every person sending these ringless voicemail that relied on the vendor to say it wasn't a call get left holding the bag of a TCPA class action, and it's horrible. And they didn't deserve that. $500 a call, you know, hundreds of thousands, maybe millions of dollars.
And the ringless voicemail company is gone, and you can't get them, even if you had an indemnity clause with them. They're not worth it. They don't have the assets to make that indemnity whole. So anyway, when you get somebody coming to you and saying, hey, we can contact your customers with ringless voicemail, they love it, it's legally compliant, have your compliance people take a look at that. And the same thing comes with artificial voice. If they say, we can contact people, it's totally legal, okay, that sounds great. Let me have my compliance team check it out, because this is not the first time this has happened. The TCPA plaintiffs bar is extremely active. The ones that haven't retired on islands already, but the ones that are still out there will kick the tires on any claim that your artificial voice calls comply with the law. So you better kick the tires on that before you make the calls.
Right, right. And that's what we're here to talk about, the compliant use of this technology, because AI isn't going away. We want to warn people on how to use it in a compliant manner. There is a way to do it properly. We don't want these TCPA cases to continue to rise. And we want to educate people on what the right things are to do. And I'm glad that you brought up ringless voicemails, because let's not do those, right?
Yeah. Well, unless it's otherwise legal. I mean, if it's legal under the TCPA, if a pre-recorded call would be legal under the TCPA, a pre-recorded ringless voicemail, it's just treated exactly the same, because it's the same clause, pre-recorded or artificial voice call. So ringless voicemail, AI, your old-fashioned, pre-recorded delivery of a call, it's all subject to the same restriction.
Yeah.
There's nothing special about it.
Right. The IS-26 software for the iPhone has a solution that matches ringless voicemail now. Your phone is programmed to send anything in your contacts directly to your voicemail. So consumers can lean into things that the carriers are providing to also block phone calls that they don't want.
And that raises I'm sorry, go ahead, Tammy.
No, go ahead.
That raises a really good point about 3 Supreme Court cases that are relevant here. The first one is called Loper Bright, and it's from 2024. And it just reinforces what I just said, that judges and courts look to the language of the statute, and an agency interpretation that conflicts with the statute is not given any weight, is not giving any deference, is what the court said. So if somebody comes to you and says, oh, this agency says X, Y, and Z, look to the language of the statute, because the statute controls. And if something says call, you look to the plain English definition of call before you look to any FCC interpretation. So Loper Bright said the language of the statute is what controls. The second case is Facebook v. Dogood, which is from 2021, and it was a TCPA case. And what it rejected was the plaintiff's argument that any computerized dialing violated the TCPA. The Supreme Court rejected that, again, based on the language of the statute. The language of the statute says, creates a number to be called using a random or sequential number generator. Well, nobody does that. That's like 30-year-old technology. Everyone loads a list of numbers and then dials it however it's dialed, oldest to newest, or by area code, or by time zone, or whatever. So this is a good thing. The Supreme Court has said automatic telephone dialing system is this, random or sequential number generator. It's not predictive dialing. So you can predictively dial, and your AI campaign can call a loaded list of numbers, and it's no longer relevant. The human intervention test is no longer relevant. So that's really good. So those are 2 Supreme Court cases that kind of help us on the compliance side, A, look only at the statute, B, not worry about computerized dialing being a problem. The problem is the Facebook case did not address that pre-recorded or artificial. Those terms, pre-recorded or artificial voice, are very plainly defined, and the TCPA restrictions still apply. Artificial intelligence uses the term artificial. I mean, you can't avoid it, and nor should a vendor can. It's subject to the TCPA. It's subject to other state laws involving pre-recorded calls. But that's okay, because for marketing calls, the TCPA would allow these with prior express written signed consent. And if you go out on the web and you enter in, on Lending Tree or something like that, there'll be disclosure language. And if they've done it right, that disclosure language should gather prior express written signed consent such that you can contact that person if she's on the do not call list, or you can contact them with this technology, assuming that that disclosure language is properly written.
Mhm. You know what I want to talk about is the other case, Bar v. AAPC. As we're talking about pre-recorded calls, around the time when this prior express written consent came out to match the pre-recorded call rules, you had to argue on behalf of First Amendment speech, freedom of speech, because government debt calls wanted to get an exception to this.
Yeah, and this was a funny case. It was the first case that was argued remotely during COVID. And my partner at the time, she's no longer here, had argued at the trial level and the appeal level. And then a heavy hitter Supreme Court lawyer took over for the Supreme Court. His name is Roman Martinez, and you might hear of him someday when he's appointed to the Supreme Court. He's extremely smart and was nice to work with. And during his argument, this is the very first one, a toilet flushed. And afterwards, people were interviewing him and saying, "Did you flush the toilet?" And he said, "Of course I didn't flush the toilet. I'm arguing before the Supreme Court." But the Supreme Court also has many septuagenarian and octogenarian people who might not have been familiar with how to turn their microphone off. And they might have been at home and maybe their grandkid or something was next to the study, but somebody flushed the toilet. But the case,
Oh my.
yeah, the case carved out an exception for government debt from this TCPA restriction. And we argued that because of that, the whole statute was unconstitutional. And the Supreme Court agreed with us to an extent. They said, yeah, this exemption is unconstitutional. It favors government debt, but we're just going to get rid of the exemption rather than getting rid of the whole thing. So it was kind of a Pyrrhic victory. But it did set up the later case, which was the Facebook case, which was a huge victory. And the TCPA plaintiffs bar, they didn't just go away when the ATDS argument got rejected. They've moved on to other things like AI, like ringless voicemail, like calls that are outside the 8 a.m. to 9 p.m. curfew. And the 8 a.m. 9 p.m. curfew has an exemption for prior express consent. Like if you're on a tech chat at 2 in the morning and you say, "Call me," well, somebody can call you and give you tech support, and it's not a violation of the curfew. However, there are plenty of plaintiffs firms out there, even with express consent, who will say a call at or text at 10:05 p.m. is illegal, and then you're faced with a nuisance level TCPA defense. So I would recommend complying with the curfew for all these calls and texts, with the exception of that tech support, which is like a 1-to-1. We're going to call you back in 5 minutes or something like that. So yeah, it was quite a case to go to the Supreme Court, and we didn't get all the way there, but we got part of the way there. So
yeah, it was still a victory.
Yeah, it was. Yeah.
Yeah.
And they never tracked down who flushed the toilet, but it's probably for the best. What are the regulatory requirements and restrictions for outbound voice AI? Well, it's pretty tough. Assuming it's a cell phone, you need prior express consent. If it's a non-marketing or non-telemarketing call, you need prior express written signed consent for a marketing call. And a signature can be obtained electronically. It can also be obtained on the telephone if you record the call, because the TCPA has said that a signature includes signatures within the definition of e-sign, the Federal Electronic Signature Act, which defines a signature as a sound, symbol, or process associated with a record given or received with intent to sign. So if you had a script that said, Ms. Fowler, do you consent to us contacting you about your account? Please press 1. You press 1, that's recorded. Either the whole thing is recorded, like an oral recording of the call, or just the key press is recorded in electronic form. That's a signature as far as the TCPA goes. Similarly, an unchecked box that says check this box to provide your consent, that would be fine, or even a submit button that has disclosures that are clearly and conspicuously disclosed above the submit button. They click the submit button, that's fine. And I would be happy to share with you, Tammy, I have shared with you a checklist of all those
Right.
elements: prior, express, written, signed, consent. Each of those terms have meaning. They each need to be in there and clear and conspicuous. But if they're there, you can make these AI calls. Toward the end of my presentation, I would talk about, I'll bring it up later, but I'll tease it. The FCC did propose a ruling. Comments ended at 2024, so it's kind of a year old, but it also was a change of administration, so they might not be interested anymore. That would require an additional disclosure for AI calls, but that's not the law right now. That's only been proposed by the FCC.
Right, right. All right, so we have consent. Now let's talk about the disclosures at the federal, state, and then these state-specific disclosures, which I'm sure many people are not aware of, depending on the type of call that you're making, whether it's political, marketing, informational only, nonprofit. There's disclosure requirements for every type of pre-recorded call to be made based on what you're doing at the federal level and the state level.
Yep.
And then
And they would be the exact, yep.
And while you're on that, let's talk about this ADAT registration, automatic dialing announcing device, which is different from an ATDS,
Right.
that I'm sure our viewers are not familiar with. There's a registration requirement of this type when you're using pre-recorded call. Let's talk about that.
So the first point was the disclosures. You're going to have to disclose the name of the caller, the purpose of the call. If a sale is made, I don't know if your AI can actually do that, but if a sale is made, additional disclosures need to be made before the consumer pays. And the consumer paying is defined as that person giving you the information that allows you to process. So obtaining the credit card number or the bank account number is paying, even though you don't actually have the money in your account yet. There are plenty of disclosures, and this is a very developing area of law. There are not a lot of laws out there that specifically apply to AI. So we're going back to the general telemarketing laws. We're going back to the general pre-recorded call laws,
Right.
which require disclosure. So again, talk to your compliance team. If somebody pitches this to you, have them give you what the script might look like. And none of the statutes require specific language. They require a goal, like disclosure of the identity of the caller, but they don't require it to be, my name is Bill Rainey or something like that. It can be done in ways that your marketing people can say, this is going to have the most effect as a effective script. Or, because it's artificial or pre-recorded, you can try different versions and see what works as long as the legal elements are in there. Obviously, you can't be deceptive. You can't be abusive. And the deception has come up in the AI area with voices pretending to be somebody else, whether that's a politician or whatever. You can't do it. Just like you can't use the name of a different company. It's the exact same rule that would apply to a live voice campaign. So no deception. The ADAD registration that you mentioned is, again, a relic of bygone times, but those laws are still out there requiring that entities using a pre-recorded voice to contact consumers get a license. Usually it's a very low fee. It's not a difficult license to get, like, an insurance broker's license, but they are out there. And you wanna run through those before you start this type of campaign, especially if you're a big company, because you can be a target. You're not as much a target on that type of statute from a private lawsuit, but the TCPA, like I said, is enforced by private class actions, not so much the FCC, although the FCC can enforce it. And you get state statutes that they're called private attorney general statutes that allow individuals to sue for compliance. Now, usually they have to be harmed by it, but not always. And there's a good example that is relevant to AI, which is in California. There's a statute that requires that both or all parties to a conversation consent to it being monitored or
Mm-hmm.
recorded. And listening in a third party listening in counts for quality control, counts as monitoring.
Mm-hmm.
And your classic recording counts. And that comes up just as much in a text chat, which might be recorded in text, or an AI call that might be recorded not in the sounds, but in the transcript of the conversation. So that statute has a private attorney general clause, and there have been lots and lots of class actions in California for failure to disclose monitoring or recording on outbound or inbound calls. It's a
Mm-hmm.
really tough statute. Again, your compliance team would be able, is this a deal breaker? Does this mean you can't do it? Absolutely not. It just means you need certain disclosures in there that say your chat today can be monitored, or
Right.
something like that. And the
Yeah.
cases have said if a person continues with the conversation after notice of monitoring, consent is implied and it's effective. They don't have to sign or check yes or say, yes, I agree or something like that, but they do have to get that notice. So the ADAD registration is another type of restriction. It's at the state level, not at the federal level,
Right.
but you have to worry about federal and state. And that California thing is kind of weird because California is such a big state. We don't know if a person with an 816 area code like I have in Missouri is currently living in California. And until somebody resolves that question, you pretty much need to make that disclosure to everybody because you don't know if somebody's in California. California is such a big
Right.
state.
Right. I was going to say that some people just default to placing that call monitored recorded message at the beginning of their calls just to
Yep.
be safe.
Yep.
Yeah,
And
it
if
takes
you do make that disclosure and you get a lawsuit, it would be very easy to dispose of because the cases, luckily, have been pretty favorable, saying,
Yeah.
if you do make that disclosure and somebody tries to rip you off, they'll get
Yeah.
kicked out of court. So what can you do? Well, we've already said that the outbound pre-recorded voice is prior express written signed consent. That's pretty restrictive. It's not impossible, but it's pretty restrictive. And so if you wanted to do that, you need a very narrow set of consumers who've opted in. But there's some things that are much easier to do with AI. Inbound calls. Um,
Right.
Inbound is unregulated. With the exception, you can't be deceptive and you can't commit fraud. Okay, I'm going to say that you can't commit
Right.
fraud for
And on the
anything.
upsell on
But
certain types.
inbound calls do have upsell restrictions, but generally AI would be permitted in that situation, and you don't have additional disclosures or additional restrictions. Just what generally applies, and you could use AI for inbound. And then
Mhm.
obviously, it's a business decision about when that conversation gets escalated or referred to a live person or whatever
Yeah.
to handle a problem. Inbound text chats, similarly, you still need that California disclosure regarding monitoring, but inbound text chats are going to be
Mhm.
pretty easy. And here's one that is surprising, but falls within the easy category rather than prior express written signed consent. Outbound text is okay. Outbound text is not considered pre-recorded or artificial voice. The text itself.
Right. Right.
Now, if you had an embedded video with voice or something like that, it gets a little bit more hairy. There's a case that just came down that said an embedded video is not a pre-recorded voice, but I wouldn't risk it. We have this system of laws here where there are 50 different states. So if you have a court case in one state, somebody else in another state could still make that argument. And that argument is out there that an embedded video is a pre-recorded voice. So I wouldn't do it
Right.
until somebody like the Supreme Court or Congress has a
Yeah.
nationwide solution. But the text itself has been ruled pretty uniformly to not be an artificial pre-recorded voice. So an outbound text campaign, you first have to ask, does it comply with the national do not call list? So if it was
Mhm.
non-advertising or sales, then outbound text is just fine. And it is not subject to that cell phone restriction, pre-recorded or artificial voice. So outbound text for non-marketing is pretty easy. Again, you want to run it by your
Right.
compliance team. Make sure you're checking the boxes, monitoring, registration, whatever. But outbound text is probably okay. And then
that
if it was
embedded
from, go ahead.
and that embedded video, because it didn't automatically play and the consumer would have had to push play. That's why the court said,
That's why the court ruled that way.
yeah,
And I think it was a district court case. It might have been Ninth Circuit. It did just come down.
yeah,
I wouldn't quite rely on that. If it was my business or my client,
yeah,
I'd
I wouldn't.
say I would stay away from embedded video for now. If
Exactly.
it was
Same.
retrospective, so I always talk about prospective compliance and retrospective litigation. And I used to say $1 of compliance was worth $10 of litigation. Now I think it's $1 of compliance was worth $100 of litigation. I mean, it's just
Yeah.
your dollars are so much better spent addressing a problem in advance rather than with litigation. But if we were in litigation and you had an embedded video, you have a strong argument that that's okay. And the case just came down that said that's okay. That's not a pre-recorded voice. It's just, if this was prospective, I would stay away from it for
Yeah.
now, unless I had prior express written signed consent, in which case, your pre-recorded voice is legal. So anyway, outbound text is something with AI that you certainly can do and be a little bit more open. You still want to make sure your compliance team signs off on it. Still want to worry about federal and state laws, but it's going to be much less restricted than outbound voice. Why is that? No one really knows, other than the fact that the TCPA was passed in 1992 before text even existed.
Mhm.
And then the final, and I don't know if this is as valuable or not, but email would be very accessible for AI.
Yeah.
Because CAN spam, which is the federal email law, doesn't require consent, doesn't require a relationship. Cold email is permitted, again, no fraud, no deception, but
Right.
AI is okay in that respect. So that's for inbound calls, inbound text, outbound text, and email, where this is a very
Yeah.
viable commercial tool for businesses. I always like to say, as a lawyer, I'm not trying to tell you no. I'm trying to tell you,
Right.
yes, here's how. And in those 4 areas, yes, here's
Yeah.
how definitely applies.
Let's make sure our viewers understand the interactive opt-out that has to be among the disclosures when you're using pre-recorded calls and how it needs to be up front. Um,
Absolutely.
so, I
Yeah. And
mean,
this is a business reason why you don't, I'm not going to use a hammer these people, because they're your customers and you spent a lot of effort and time and money probably getting prior express written signed consent. And, I get them when I opt in and it says, you get a 15% coupon if you sign in for texts. Well, if they send me 10 texts in a day and I say stop, well, then they just wasted that 15% coupon, and that's real dollars. So
mhm,
you have to honor opt outs. And part of honoring opt out is probably not texting or calling as much as you can, because that would just increase your opt out rate. So a text should have, even if it's exempt, like a political text, should have something at the end that says stop to stop, or something like
yes,
that, because consumers expect it. And A, it's
yeah,
going to look scammy if it's not there. But B, you kind of want to respect your audience and let them opt out. And then once you give them that option, you have to honor it. You can't just ignore it. That's creating complaints. That's how you get in trouble. And it's the same thing with pre-recorded calls. There needs to be a key press opt out. Um,
mhm,
and you need to honor it. And there is a new area of TCPA class action litigation where the system might not honor that opt out immediately. Now, the regulation allows a reasonable period of time up to 30 days, and it just changed to up to 10 days.
10
But
days,
these
yeah,
plaintiffs' attorneys have said, oh, no, it says reasonable period of time up to 10 days. So I'm going to argue that 5 days is not reasonable, or 2 days is not reasonable, or 30 seconds is not reasonable. And that ends up being a question of fact. But a question of fact is decided by a jury in a trial, and that's all the plaintiff's attorneys want. So
mhm,
if there is an opt-out option, you want it to be instantaneous, that the person will not receive
right,
texts or calls after that. And if you can't honor it instantaneously, then you need to create a record about how any delay is reasonable. And that would be strong medicine if you were sued. the plaintiff is probably not going to have enough fight in it they'll move on to easier targets because all they care about is money. But I would rather not be a target at all. Instantaneous opt-out is what I recommend because of the
Right.
abusive TCPA environment. And there's a firm out there, can't forget their name, but they filed thousands of these. And the similar thing with those texts being received after hours, thousands of them. So it behooves you, even if it was legal, to not make texts after hours, to honor stop requests
Yeah.
immediately, just because of the environment
Yeah.
of litigation that's out there.
So best practice, for a text, make sure you have an opt-out that you can honor. When you're doing pre-recorded call, which is an AI call, even though at the beginning of this webinar, you said AI, the announcement of AI is not being enforced right now. I think you should still say, I'm an AI assistant with contact center compliance. If you no longer wish to receive calls, press 1. Here's the pitch.
Yeah, and that's very conservative advice, and you're not going to get in trouble. And when I advise my clients, here's the line. Sometimes there's gray on either side of the line, but do you want to be here? Do you want to be here? And I call this low hanging fruit, where the plaintiffs can reach up and get the low hanging fruit. I'd rather be high hanging fruit, to the extent that you still need to do business and make money. So
right.
Yes, there can be some risk. Yes, there's always going to be some low level. Okay, anybody with $5 or $200 or whatever it is can sue you. We don't want to be low hanging fruit, except to the extent that, if we're complying with the law, if we have a strong record of it and somebody sues me anyway, well, maybe we'll take the offense then and try to get sanctioned. Problem is, in our system of law, generally each side pays their own attorney's fees. It takes a whole lot for that to be changed, but still, a compliant business should be able to do business where the law allows. I just, if it's in those gray areas toward the line, I would definitely make it a conscious choice to do that, rather than, oh, this vendor told us it was okay, now we're near the line. I wouldn't want to put that on my boss
Right.
or my team.
Right. Let's
So there were a
lean
couple.
into. Oh, I'm
Go ahead.
sorry. I wanted to lean into your privacy. You're a
Yeah, I was going to say, yeah. And
certified
we want to leave
information.
some time for questions.
Yeah.
The privacy regime is interesting in the United States. In Europe, there's the general, data practices rule, which applies, every EU citizen. We don't have that in the United States, but we do have a comprehensive law in California, which kind of has the same effect that California monitoring statute has, because it's such a big state. And once California does something, it kind of turns into quasi-national restriction. Many states have copied California's law. I think 3 or 4 just went into effect on January 1st. So now we have 15 states, something like that, with comprehensive data privacy laws. And when I write a privacy policy, I don't break out California anymore. I just say your state rights, because if you broke out each state, you'd have a document that was 50 pages long or something like that. And you don't really want that. There are lots of privacy policies out there. You want to make sure that you're staying up to date regarding new states that come online. They largely follow the same format, but some give more rights. The right to verify, the right to correct, the right to delete, and some of them change. Most of them don't have set language that they require in the privacy policy, but some do. So you do need a compliance person, a professional, to look at that. And what I would say, the most important thing with your privacy policy and your terms and conditions is to have a class action waiver. So if somebody opts in on your website, they're agreeing to terms and conditions that any claim against you is subject to arbitration and it is not in a class action. And that's fine. I mean, we're businesses. We try to comply with the law. I just don't want to be hammered with somebody whose real interest is a third of attorney's fees, not consumer benefit of any sort. And to do that, you need good privacy policy that's up to date, that explains in clear and conspicuous ways what the consumer's rights are. It's not hard. Maybe a 10 page document, and have a tickler that you evaluate it probably twice a year to make sure that you're keeping up to
Right.
date with the new statutes. There are email addresses or 800 numbers that need to be in there so people can exercise their rights. You need to
Right.
make sure that those inbound means of information are staffed. And usually you have up to
2
45
forms.
days to respond to a
Yep.
request, that any escalation is properly handled by your compliance team or lawyers. And then the third thing I mentioned was your terms and conditions need that class action waiver. If you're going to be reaching out via text or telephone, class action waiver, it's not very long, usually,
Mhm.
half a page, clear and conspicuous. But the absolute essential point is the person opts in to those terms and conditions. That's called click wrap. That same box that says, I provide my signature expressly consenting to Bill Rainey contacting me by telephone or text. It also says, and I agree to the terms and conditions. And those terms and conditions are prominently hyperlinked, and the person has to
Right.
affirmatively check, I agree. And that's called click wrap. And click wrap is generally enforceable. Shrink wrap, when you just unwrap a package and it's there, that's not generally enforceable. And browse wrap, which is just a link down there and I might click on it, I might not generally
Mhm.
enforceable. And once they click on it, if it was 500 pages, they probably have an argument that, oh, such and such a clause is buried. I didn't really
Right.
read it.
Right.
But if it's 9 or 10 pages and it's clear and conspicuous, it has good use of bolding, good organization,
Standard
that's going to be
format.
enforceable and
Yeah.
it's going to protect you. You're a legally compliant entity, but you still don't want to be involved in a class action because they get expensive fast. And the plaintiff's argument is this, say they have $500 a call, they have 1 million calls, even just 100,000 calls. That's $50 million. And they might say, okay, hey, Bill, I realize you're a really good defense attorney. You have a 99% chance of winning. 99% times 50 million is still what? $500,000? I don't know, whatever it is. It's still a lot of money. And you don't want to be tied up, even if you're have the strongest case, you don't want
Yeah.
the class action at all. Terms and conditions with a good click wrap disclosure is going to protect you.
Yeah. Yeah. And what about, before we go to questions, just data collection, privacy and data collections, especially when you're gathering information from consumers, you want to make sure that you have the proper consent to use it the way that you're using it.
Yeah, and it's in the privacy policy. The privacy
Yeah.
policy requires, the disclosure of the categories of information you use and how generally you might use it. You don't need to disclose to each person exactly how you're going to use their information, but it needs to be disclosed in a general way. And luckily, I mean, the California statute, there's lots of stuff out there that gives good guidance about that.
Mhm.
We haven't seen a lot of case law in this area yet. We see case law with lawyers being bad lawyers by using AI to draft their briefs. Not really relevant here. There is a case called Levervitz versus State Parkway Condo where the button in an elevator in a condo was programmed to dial the superintendent, button broke, call
Yes.
for help. And then
Yeah.
he changed jobs, was no longer working, and they never reprogrammed it. He complained several times. Eventually, he sued and he won. They said, you're calling this person with no consent with a pre-recorded call, even though it was a button on an elevator. And then the final one I found was De Mesa v. Treasure Island, which involved an automated check-in where they sent this person saying, hi, I'm Ivy, your personal text help at Treasure Island. Text me if you want to help checking in or whatever. And the Supreme Court said, not the Supreme Court, the court in De Mesa said the person provided her number. This was a non-marketing text. Provision of the number is consent for that sort of message. So that's what we're going to find for now as
Yeah.
the cases develop. But there's not a lot out there. We're going to see more probably at the state level first under this administration. But, it's definitely there's an existing regime out there. You can do it, but just make sure you do it right because the downside is pretty bad if you do it wrong.
Yeah. Exactly. All right. Let's see. Let's get some questions here. Here's the first one, Bill. Some vendors won't allow you to use an outbound calling campaign unless you have a fixed static script for each call. This seems to be a misunderstanding of the law, then as the issue isn't the script, but the requirement for prior consent. What are
Yeah,
your
that is,
thoughts?
the questioner is exactly right. That's a misunderstanding. There's nothing that requires a set script to any person. Now, maybe they're saying that because it's easier on their end to verify compliance. But for me, if that was the situation, I would say, here's our script. We will guarantee that every script discloses these elements, but then it's also a dynamic script based on the responses from the consumer. There's nothing that requires a set script. I see that a lot with regard to human dialing versus
Yeah,
predictive dialing. And there are still plenty of people out there who say, well, why don't I do click to call? And I'm like, I mean, you can do it if you want to, but it's no longer legally relevant whether a human initiates a text or a call or the computer initiates it because of that Facebook decision. And there's a slight caveat to that. In 3 states since Facebook, they passed laws that reinstituted that. But assuming you're not in Florida, Maryland, or Louisiana, and again, this is what your compliance team should be able to recognize. The click to call is no longer relevant, but I still see people asking me about it all the time.
mhm. Here's the other one, are pre-recorded voicemails, not artificial pre-recorded voicemails prohibited. These are pre-recorded voicemails recorded by sales staff in their own voices
Yeah.
using power
Oh,
dialers, not an ATDS software to each potential client. Is that allowed or prohibited?
well,
This took a
and
lot of
and
turns.
and I understand that. The funny thing is, like, some people say to me, it's so inefficient, and I'm like, this is a law that's 30 years old, and they didn't recognize this technology. So if it's an artificial voice delivering a message on a voicemail, that counts as artificial pre-recorded voice. If
Yes,
it is a human like
human.
me, I pre-record the answer, and then that pre-recorded message is delivered on the voicemail. That counts as a pre-recorded voice. If I, as a live person, leave the
Leave a
message myself,
voicemail.
that's a live voice,
Yes.
and that doesn't count. And why on earth is there a distinction there? There is no. I mean, this is the Telephone Consumer Protection Statute. How is a consumer being protected by that distinction? They're not, but that's what the distinction is. So if you're saying the live employee records a message, and then when her system detects voicemail, she can just click that button and deliver her own voice. That would only be
Sorry.
allowed with prior express written signed consent.
Yeah, sorry, it's still pre-recorded.
Correct.
Yeah. Someone says, can you provide the checklist for consent you mentioned in the call earlier?
I'll email it to Tammy and she can forward it as needed.
Okay. Let's see, we've still got 8 minutes. What specific use cases fall clearly outside, whoops, pre-recorded, hang on, or artificial voice, and where does risk begin? What specific use cases?
Well, an emergency call is outside. And I have clients that are utilities or provide services to utilities. And the definition of emergency calls for utilities is pretty broad. It's not like life and death, power line down, like a scheduled outage. And if you think about a hospital or somebody with a breathing machine or
Mm-hmm.
something that requires, a source of power for health, it makes sense. So that's a use that's fine. Um, if here's a use that's not fine. Like, I've had plenty of political clients who said, I want to get this message out. This is a database of registered voters. And that is not consent. They might have given their contact information to the local voting authority, but they didn't give it to candidate A or PAC B or whatever. The consent needs to be given to the entity making the call. Similarly, a web search or a grab of numbers or purchasing from a third party, that is not consent alone. So that is not a safe use. And then you get into express consent for non-marketing. I just had an example today with proxy votes for stockholders. If the consumer has provided her number to the caller and not made instructions to the contrary, then that is express consent for a non-marketing message. So
Mm-hmm.
appointment reminder, proxy vote, I just said,
Mm-hmm.
even like a recall of some auto part might even be an emergency. It depends. So those are some safer use options. And then the more you get into marketing, the more and more restricted it is, ending up with that prior express written signed consent being the most restrictive level. And this is kind of a good thing. Under federal law, if it's allowed under prior express written signed consent, that definition, and I'll send the checklist, is so restrictive that meets the definition of prior express written signed consent in every state as well. So that's an example of the federal kind of giving a one-stop solution, albeit a restrictive one.
Mm-hmm. Good, good. Here's another one. What should compliance teams audit first? Scripts, systems, vendors, or data flows? How should AI vendors be contractually obligated to support compliance and audit trails? I
Well,
like
I
this
always
one.
like a legal compliance section. So I look at a lot of contracts for my clients, and sometimes my clients are both, a vendor and I mean, I wouldn't represent them both in the same thing, but I represent
Yeah.
service providers and clients. And I say everybody's interest is in compliance, and you want a legal compliance section, that both sides agree to comply with all applicable law. And then you want an indemnity section that has both parties agreeing to be responsible for breach for the things that are under their control. So if I'm providing the numbers and I represent that these numbers are prior express consent numbers, and you call them with a compliant script, and then somebody says, oh, this number wasn't consent, that would be on me, the seller. So that would be the language I look for in a contract: mutual indemnity for the things that you're responsible for. You have to go beyond that. I gave the example of the ringless voicemail companies, disappearing into the hills. The
No one to
entity
go
has to
after.
exist. I mean, for you to get indemnity, they have to exist. And if you're a
Yeah.
deep pocket, you have to realize that you're the one that's going to be the target, not some vendor who doesn't have the ability to pay the indemnity in the first place. So dealing with a reputable company who does, and there are plenty of reputable companies out there, as well as the contract language, would be important. And then as far as the audit goes, I mean, I would think that it's not so much what you start with, it's that you do start, and you
Right.
create a record, and that record
Right.
is just supplementing. You just don't do it one time. If you had a contract with legal compliance section and it's really good, but then you never looked at the contract again, and you never, if they got a complaint or something like that, you never investigated it. Well, the contract's not really worth the price, the paper it's printed on. You have to ongoing pay attention to these things. If you get a complaint, you investigate the complaint. I always think, that's smoke. You need to look and see if there's any fire behind the smoke, because, sometimes a little bit of smoke can give you a clue to fix something, or it can also give you a clue, oh, we checked it out, this is just fine. And then you get something more serious, and those more serious people might say, oh, you've ignored this all along. And you can go back to your records and say, no, we always investigate things really, and keep records. So it's much more of an ongoing thing rather than like, what would I look at first?
Yeah. In any order. Just make sure you look and you have an audit trail.
Oh, absolutely.
All right. Announcing at the start of an AI call, it is an AI call, is okay, or I didn't understand.
Not required yet. Best practice.
Mhm.
So
And
I think you understood it. It was just Tammy. Well, go ahead, Tammy. I think that is conservative advice.
yeah, yeah. No, you're absolutely right. That's what I said. Let's see, one more before we quit here. Let's do a California one. In California, there is recent regulation that requires that the first words a consumer hears is from a human. A human can introduce pre-recorded AI voice after connection. What do you think about this? How does this apply to AI generated voice in California? And are there other states headed this way?
Well, where
That's it.
California goes often is where others go. That regulation is news to me. I will go check it out, and it wouldn't surprise me at all. But yeah, it's such a big state and such a big part of our commerce. And because you don't know where somebody is based on area code anymore, there have been suits with people with non California area code suing with California law. And, you, the caller, are left to say, how am I supposed to know? And, I don't know, you just are. So, being conservative with regard to more restrictive state statutes is something I advise. And like I said, I try to be an attorney who doesn't say no. I try to say, here's how you can do it. And an ideal client asked me that question before they've started doing it, because I think a lot of times there are ways to get it done. But yeah, you have to keep track of all this stuff all the time, and it changes a lot. And the legislators are in session right now, so we can get new stuff any day.
All right, this was good. 1 minute left. Let me just thank you so much, Bill. It's so good to see you. Thanks for
It's good
coming
to
on
see you.
here.
It's
I
always been a
appreciate
pleasure
it.
working with you, and I always look forward to it, Tammy. Thank you so much.
You're welcome. So you take care and goodbye, everyone.